Under the Arbitration Conciliation Act, now arbitrators appointed. Now, for the purpose of enforcement of your arbitration agreement, you come to here, the court defined is again a district court. Now, for the purpose of obtaining interim orders under Section 9, before or after the arbitration is invoked, it is the High Court in Bombay City, which is the district court. You file petition for interim orders, for appointment of a receiver, injunction, any interlocutory order. Whether it is not necessary that you have invoked, given notice under Section 21 for giving effect to for enforcement of the arbitration. Even before appointment of an arbitrator under Section 11(6), which the High Court appoints normally, district court. Now you can go for interim orders, it is the High Court. But elsewhere, Pune City, Thane, you can go to a district judge. The principal district court, you can go and invoke your jurisdiction in the matter. So that is one. That is the jurisdiction of the Bombay High Court in matters which are called original jurisdiction, which is coming directly under Section 9 of the Code of Civil Procedure, read with Clause 12 of the latest patent. Please note that. Latest patent Bombay, आपको CPC में मिलेगा, Bombay High Court rules में मिलेगा, and you will also find it. In the original side of the appellate side of the rules, and in the CPC it is also annexed to all good books such as universal publication. Any of the books they have appended to it. Okay, these are the original suit matters which come under Section 19. Now in the CPC, Section 9 tells you jurisdiction, and Section 15 कहता है कि every civil suit should be filed in a court of lowest grade and jurisdiction, having jurisdiction. So lowest grade means you cannot directly go to the Supreme Court under Article 131 of the Constitution, isn't it? You cannot go to the High Court under Article 226 of the Constitution. You cannot even go. So you had to go as per the jurisdiction which has been vested with the court. So for that purpose, the provisions of in the state of Maharashtra, the Civil Courts Act, you have to take into consideration the enhancement of Pecuniary Jurisdiction Act and the Code of Civil Procedure, and the rules framed by the High Court, City Civil Court, and Bombay High Court. You have to bear in mind in this regard. Please note that here. So it is this, the civil. You cannot go to a civil court unless you first determine the jurisdiction. So in the Code of Civil Procedure, for determining which court has jurisdiction, which matters can be taken up, Section 9 tells you every suit is a civil suit which can be brought in a civil court. Now I gave you the illustrations of a civil court: a district judge, additional district judge, civil judge senior division, a junior division, small causes court of 1882 Bombay, and in Pune Varame, provincial small cause court of 1887 in Pune city, who are equivalent to, they are also called municipal courts. So these are the various courts. So you decide, like we have in the city of Bombay, apart from this High Court, City Civil, Small Causes Court, we also have a cooperative court exercising powers and jurisdiction under Section 91 between members and societies, on all person claiming through members, because nowadays there are a lot of housing societies. The disputes falling within the ambit of the Societies Act, they go to the cooperative court now, which is situated at Churchgate near KC College, isn't it? That jurisdiction is under Section 91. All disputes between society and member and the person claiming under member touching the business of the society shall be filed in an exclusive jurisdiction of a cooperative court. And you cannot go to City Civil Court, Bombay High Court, Small Causes Court in that regard. So on the point of jurisdiction, there are lots of judgment. There were earlier we had a section called 9A in CPC with application for the state of Maharashtra, and that section was abused and misused by lawyers and everybody. Ultimately, the Supreme Court deleted it because on the ground that the court has no jurisdiction, a preliminary issue used to be framed. Time was wasted. Appeal used to go, second appeal, then High Court, Supreme Court. Because jurisdiction issue is covered under the CPC and Order 14. Order 14 में cover हो गया. It is the discretion of a judge to frame it as a preliminary issue or not. समझे ना आप? So that is the point before the court, where the court. Then, so you understood the various mechanism, the scheme of the various civil court in the state of Maharashtra and particularly in city of Mumbai. Then we have a courts apart from the consumer court. We have a consumer court. But consumer court is not a civil court. It is in the nature of a tribunal. Please note that it's a tribunal, and it clearly says the act. When you read section 100 of the Consumer Protection Act, this act is in addition to and not in derogation with any other remedy which is available to the parties. So apart from the Consumer Act, you can still go to civil court if you are not satisfied that the consumer court is not given. Because consumer court ke paas, the provisions of the CPC and Evidence Act are not strictly applicable, though they may invoke it. Because they go by the principles of justice, equity, and good conscience in the matter. Okay. So that is the, then we have in the matter of, in the city of Bombay, apart from the consumer courts and this court, you also have tribunals such as CAT and MAT. MAT is a Maharashtra Administrative Tribunal. Service matters between the government of Maharashtra and the employees, and central government employees, and state. We have CAT in the matter, that is it. Then we have labor courts exercising powers in the matter of, these are also tribunals in the, strictly speaking, under the Industrial Dispute Act, Workmen Compensation Act. So they adjudicate the dispute in the matter. Whether now we also have the Arbitration and Conciliation Act. Those who do not want to come to the court of law, which the trials are very, the prolonging takes longer time, speedy, not a speedy justice. So parties may invoke arbitration, especially in commercial matters, not in all matters. Certain, of course, the scope of the arbitration is enhanced now. So the Arbitration Act के अंदर again the provisions of CPC are strictly not applicable, but wherever if the procedure is silent, the arbitrators can invoke, there is no bar. Even the provisions of Indian Evidence Act are not binding strictly upon the, because arbitrators are tribunal. They are not a civil court. So whereas the provisions of CPC Evidence Act are strictly applicable to the courts which are civil courts, which I defined to you, the district court, civil judge senior division, a junior division, and the city of Bombay City Civil Court of 1948, small causes court under the 1882 Act. These are the courts. Of course, Family Court Act, where the family disputes also concern, is actually the provisions of CPC and CRPC are strictly not applicable. But in the absence of any rules in the Family Court Act, the CPC can be invoked. But as I see that here, most of the family court judges are invoking CPC in every walk of life here. There is no bargain. So the role of CPC as a procedural law plays a vital role in determining your civil remedies in the matter. So since the CPC is not defined the civil court, you must have the copy of a Civil Courts Act. Civil Courts Act of Maharashtra, if you are practicing in the city of Mumbai or Maharashtra, of 1869 Act. Or elsewhere you are practicing, every state has got its own Civil Courts Act. So there are Munsif Court, there are civil judges, junior division, senior division, everywhere. Almost all the acts are pari materia. The wordings are not different here. Okay. This is the original jurisdiction of the civil courts, how you determine it. Now, what exactly the CPC contains, today being an introductory lecture, and I will tell you furthermore a little more. So after the suit is filed in the civil court, after deciding the jurisdiction, a civil law is set into motion by the presentation of a document called Plaint, Plaint, which we all of know, as young lawyers, you know that the students, they want to know that what is a plaint is defined in the Order 7 of the Code of Civil Procedure. How the civil code is instituted, is set into motion, you have to see section 26 of the Code of Civil Procedure. A civil law is set into motion by presentation of a document called plaint. What does the plaint contain? Requirement is given in Order 7. The name of the court, name of the party, the cause of action, the cause of action, the clause for limitation, the clause for jurisdiction, then the list of documents, the relief which are sought. So you are required to maintain, and it should be supported by an affidavit. That is the requirement when you read it, order section 26 read with Order 7. Section 26 mandate here. Every plaint should be supported by affidavit. I mean, why? Plaint is supported by affidavit. In case you have made a false statement, you are accountable. There is a perjury provision under the provisions of Indian Penal Code, section which section it is 192, 193. Now BNS में आ गया उसके अंदर. So a person is accountable for whatever statement you are making. That is why affidavit is made mandatory for the presentation of a plaint. The moment the plaint is filed, in the plaint you must disclose the cause of action. Cause of action is nothing, a bundle of facts. So in a suit for declaration, you may seek that here the agreement of sale which has been executed between the plaintiff and defendant tainted with fraud. Isn't it? Be declared null and void. Or the builder with whom you have booked the flat has committed breaches of the flat. You booked the flat for a consideration of 1 crore. He was supposed to give you within a period of 3 years' time. You paid the full money consideration, but the price having gone up, the builder has sold it to somebody else. Isn't it? Then what kind of a suit you will file? Again, suit for specific performance of a contract under section 10 of the Specific Relief Act for a declaration that the agreement of sale between the plaintiff and defendant is valid and subsisting, that the defendant is bound and liable to perform specifically the agreement and put me into possession and execute the conveyance. Failure to do so, the court receiver, court officer may be appointed to do this act. So these are the prayers normally queued. In the meanwhile, you seek an appointment of a court receiver. You seek an order of injunction. And a custodial agency is sought. So in the plaint, you put all these requirements. These are called cause of action. A cause of action must be clearly spelled out, and your suit should be within the period of limitation. Please keep with you as a young student a limitation bear act along with you. Suit for possession, suit for declaration, a suit for declaration and for specific performance should be filed within a period of 3 years from the date of the cause of action. The court will decide the cause of action accrued when? From the time you gave notice, from the time the defendant was required to perform the contract. That is a nature of one of these suit. You filed it before the court of law for specific performance of a contract. If the valuation of the suit is about 10 crore, it will come to the Bombay High Court in the original side. If the valuation of the property is about up to 10 crores, it will go to the city civil court. There are 2 city civil court in Bombay. One is a fort, another is in Dindoshi. The jurisdiction of the fort is from Kolaba to Mahim. From Bandra onwards till Borivali, Daisar, all the suits where the property is situated, they will go to the Dindoshi court. Similarly, the court of small causes court is split into 2. One is the principal court at Dhobi Talao, where the properties situate from Kolaba to Mahim, they come to the small causes court at Dhobi Talao, and the properties which are situated, landlord and tenant, from Bandra to Daisar, they will go to the small causes court branch of the small causes court Bombay.